So the other thing going on is we filed a new excessive force case. I'm pretty sure we're allowed to talk about this. Section 1983 case, federal court. This is a civil rights case, a civil lawsuit for violation of individual civil rights, in particular violation of Fourth Amendment right not to have excessive force used against you by police or any other government officer or employee, really. So not to be beat up by the police, basically. This is a case out of Mercer County, West Virginia. All right, so filed in federal court, Southern District of West Virginia. My client, Dallas Conley, and this is involving the Mercer County, West Virginia Sheriff's Department, involving, well, a couple officers and then some John Does we haven't identified yet. So this happened almost 2 years ago. So April 3rd, 2019 and April 5th, 2019. Now, why was it just filed now? Well, that is a crazy story in and of itself. So you have 2 years statute of limitations to file an excessive force lawsuit or any civil rights violation, Section 1983 violation in federal court. Generally 2 years in West Virginia. It could be different in other states. So federal court, as far as Section 1983 goes, borrows basically the personal injuries statute of limitations in any particular state. Now, our car wreck lawsuit type statute of limitations in West Virginia is 2 years. So that's what you have, 2 years to file a 1983 suit in West Virginia in federal court alleging violation of your federally protected rights. 2 years. The reason it took 2 years to file this case is because the criminal case hasn't been completed yet. So 2 years, it seems like an awfully long time, but it hasn't been finished. But I had to go ahead and file it because we were up on the statute of limitations. So this had to do with a guy named Dallas Conley. Now, this happened in April of 2019. My client's wife had gone and obtained what's called a DVPO against him. They had a verbal argument. And following the argument, my client left the house, the marital home, drove around, and came back a little while later. Unbeknownst to him, she had obtained a DVPO. And, these are temporary emergency domestic violence protective orders. These aren't necessarily, that doesn't mean that you've physically hurt somebody or anything like that. The standard's very low. It just means that, one of the family members, usually a girlfriend or a spouse, had articulated to a magistrate that they were in reasonable apprehension of physical harm. So it could be you made them scared that there would be, some danger to them. And they're abused all the time. And I don't know exactly what happened in this case, but it doesn't really matter. But there was a DVPO and 2 cops came and escorted the wife to the house. So my client's back at the house after the argument. It's late at night. It's dark in the house. And so he's in his house when all this happened. So here's what happened. These 2 deputies, Paetzel, I don't know how you pronounce it, and Primer. Now, Primer, as I understand, he was a deputy. He got fired for lying, from what I understand. That's alleged in here. Unrelated lying, but he exited the cruiser and walked unannounced into my client's home through a closed but unlocked front door. They didn't knock and announce their presence. My client was surprised to see 2 police officers just walk inside his house. Unbeknownst to him, his wife was outside in the backseat of the police cruiser, and they were there to serve DVPO protective order paperwork. He didn't know that at the time. Those 2 police officers walked in his house. They did not tell him why they were there, what their purpose was, but they began to approach him. It was dark in the house. They shined flashlights in his face. He had never seen the 2 officers before, and he got immediately afraid. They didn't appear to be acting like police officers. They didn't identify themselves. I mean, it was clear they were police officers, but they didn't identify the reason they entered his home. They didn't serve paperwork on him. They didn't tell him that why they were there at all. They just continued to approach him, and this is kind of scary. They continued to approach him with an aggressive and threatening demeanor. And so what do you do in that situation? He became fearful for his physical safety, and he asked them to leave. In no time did the officer serve or even attempt to serve the protective order paperwork. So they just approached him. He continued to feel aggressive. He started backing up, raising his hands so that they were visible, demonstrating that he wasn't a threat to their physical safety. The area was dark. The one deputy, Paetzel, was holding a heavy Maglite style flashlight, and who uses those anymore? They're obsolete. I guess they're heavy. You could hit someone with it. He's shining it in my client's face. He's blinding him. And it just further escalated his fear that he was in imminent danger. He's in his own house. As far as he knew, he didn't commit any crime. He didn't know why they were there. They walk in, didn't say anything about a warrant, anything. Imagine you're in that situation. Then suddenly, without any warning or any provocation from him, one of the officers, Pat Paetzel, or however you pronounce that, all of a sudden violently struck my client in the face with his Maglite, striking him near his eye, causing immediate and severe damage to his face, excruciating sharp pain. So what do you do in that situation? He hadn't threatened the officers. He hadn't attempted to flee from them. He didn't know why they were there. He just saw them in his house and he asked them to leave. He didn't engage in any physical actions which would indicate that he posed a threat to them. So what do you do? Police officers come in your house. One of them hits you in the face with a Maglite. Then the other officer joins in and begins to violently attack you. So it's sort of a self-defense situation. I get asked this question a lot. Well, what happens? I mean, can you defend yourself against an unlawful arrest? This was a self-defense situation. He's in a reasonable apprehension of serious bodily injury or death. They struck him in the head, unprovoked, unnecessarily, with a flashlight being used as a blunt weapon, with intention to cause great bodily harm or death. His first instincts were to attempt to flee the violence. So he ran into his hallway, tried to avoid another strike to the head, which a lot of times can be considered deadly force. The two officers pursued the plaintiff into the hallway, and they continued to attack him. The other officer struck him in the head with a closed fist. He punched him, basically. The one who struck him first, he began to attempt to strike him again with his flashlight in the head. Acting in self-defense, what did he do? My client, Dallas Conley, wrestled the flashlight away from the officer trying to hit him with it in the head, and then he used it in self-defense. Hit both officers. As they were violently attacking him, hit him with his own flashlight. But he only utilized the amount of force necessary to be able to extricate himself from that situation, from that danger. He thought his life was in danger. So they attacked him with a flashlight. He took it from him, and he hit them both with the flashlight. And after breaking free, he drops the flashlight on the ground, and he runs out of the house. He's in fear of his life if they caught up to him. At this point, he's still unaware that why they were there. He hadn't been served with a protective order. They didn't have a warrant. In fact, he wouldn't find out about the real reason they were there until later on at his preliminary hearing. At the time, it was just like, all right, two cops walked in my house and attempted to kill me or seriously injure me. So he runs out of the house. He drops the flashlight in the house, runs out of the house into the woods. He believes that he'd be seriously killed or injured if these two guys caught up to him or any other buddies caught up to him. So he's hiding in the woods. This goes on. He tries to arrange to turn himself in to his parole officer. He was on parole. He trusted this guy. His parole officer, this was a Friday. His parole officer says, well, just wait till Monday morning to turn yourself in. It's a Friday. I'm a government employee. I got important stuff to do. Plaintiff's mom is worried. She's able to get in contact with a U.S. Marshal, and the U.S. Marshal arranged for him to turn himself in at the federal courthouse in Beckley, West Virginia. That's Raleigh County. It's, 30 minutes away or so, but it's in a different jurisdiction. So he was willing to do that, felt safe. So the authorities were notified that he'd be turning himself in, and the federal authorities were, from my understanding here, waiting at the federal courthouse, the next county over, for him to show up. That's all he wanted. So he goes back and he gets his pickup truck, and apparently the cops had flattened the tires. So he drove to a gas station, filled his air with tires. He calls his mom and lets her know that he's on his way to the courthouse to turn himself in. So then the mom calls the authorities again and tells them, all right, he's en route to the courthouse, the next county over. So his wife is then going to meet him there to pick up the truck when he turns himself in so that she can drive the truck home. But he never makes it home. That's the second part of the story. So while on his way to the federal courthouse, this is now April 5th, several police cruisers pull in behind him and began to follow him. He immediately realizes that someone had notified local law enforcement of the fact that he was en route to the federal courthouse. At that time, he thought these cops were going to kill him, just those local cops, not cops in general. And he panicked. He believed that those guys were there. They were still trying to kill him. And he made the, in hindsight, poor decision to flee. Fearing for his life, he fled from the police. And this is a crazy case. Fled from the police car, eventually crashing his truck, still within the same county. Now, there was eyewitness testimony from a witness at the preliminary hearing and the subsequent criminal charges. The official police report says that the client got out of the truck, but the eyewitness, or two eyewitnesses from my understanding, one was just Joe Blow who's driving somewhere near there and stops with a commotion. But also, I think a state trooper had testified to this from my understanding that these are John Does. I don't even know their names yet, but they caught up to him after the crash and literally pulled him out of the truck and basically viciously beat him after that. And like if you run from the cops, that you're going to have a bad mugshot generally. And in my experience, when they catch up to you. Now, this case was even worse. And I understand the fear because all they had was the first two guys, their side of the story. It's not like they had his side of the story yet, that they just walked in his house and hit him in the head with a flashlight. The story is that there was this brutal, vicious attack on the two police officers. So the colleagues, they're looking for this guy and they want to catch up to him even before he gets out of their jurisdiction. So they catch up to him, and in the paperwork, they beat him unconscious, as our allegations, unnecessarily, just to retaliate against him for the 2 days earlier, and probably also for running. But he's beaten unconscious. But the official police report, this is what's said. All right, he crashed his truck, then he got out of his truck, and he slammed his face into a guardrail, basically. That's what they said. All right, he slammed his own face into a guardrail. Had nothing to do with the 4 or 5 police officers that were beating the hell out of him. So he's taken to the local hospital, escorted by law enforcement. I've got the medical records, diagnosed with severe trauma to his head and face, fractured nose, multiple fractures of his orbital socket, lacerations, missing teeth, severe swelling of his face, including his eyes swollen shut. All right, and I actually have some pictures I can show you. All right, there we go. That's a picture of him after he was taken into custody. That is a screen grab from a surveillance video of when he's walked into basically the processing center. And you can see that he's got substantial trauma to his face, ripped shirt, blood all over him. He looks pretty bad. And I got the call pretty quickly that this had happened. And so I actually went and met with him at the jail because I didn't know that. It seemed to me that the evidence needed to be preserved of what he looked like. And I don't recall that the mugshot actually turned up. There was something screwy with the mugshot. So I went and visited him in jail. And I took a video of him. They wouldn't let me bring my phone into the jail. And this is Southern Regional Jail. So I'm the lawyer coming in to visit him, and they won't let me bring my phone in there, which I was going to use to take pictures. So they were giving me no way to take pictures of him. So what did I do? Well, I had to improvise. So I had my laptop, of course, I had to use to write with, but it had a camera on it, right? So I used that to document actually what he looked like in the jail. So here's me meeting with him. All right, that's me. This is in one of the lawyer meeting rooms at Southern Regional Jail. So that's still him days later. And I just sort of wanted to document what he looked like days later. I mean, he had teeth busted out. He had to have oral surgery to replace his missing teeth. He had multiple orbital fractures in his eyes in different areas, and he lost vision in one of his eyes. I may have been the one that he was hit with a flashlight with first, but he had substantial and severe facial trauma. And so that was pretty interesting, that there was going to be no way to document it until I went and visited him in jail. But yeah, they beat the hell out of him. And I have no doubt, it's like if you do something, even if it's not true, to a police officer, like they when they catch up, you don't want them to catch up to you. And it's, how can you blame him for not, he wanted to get out of Mercer County and get to Raleigh County and get with the feds and turn himself in. I mean, he wasn't going to live in the woods for the rest of his life. He wanted to get to law enforcement officers that were uninvolved in the incident hitting him in the face inside his home. He wanted to get to the feds. And so they were waiting for him. It was arranged, but he wasn't going to make it because they found out that he was on his way and they stopped him. They got him before he could get there. And that's the result. Yeah, that's the result of him hitting himself. I'll play it again here. That's the result of you know what it looks like. And since I'm playing word games today, they don't care about this because they hate cops, I'm sure. But this is what it looks like if you were to just theoretically walk up to a guardrail and just smash your face into a guardrail. Not that's a good looking guy there, but this is what it would look like if you smashed your own face into a guardrail. And I don't want to violate any World Health Organization standards here. So I don't want to give any false information, but I mean, you got to do a hell of a job of headbutting a guardrail to do all that damage in one headbutt. I mean, that is a quality headbutt job. And I've done quite a bit of headbutting. I mean, again, I was a high school and college football player, Division I football. I was a bouncer. I worked as a bouncer at some bad spots in Orlando while I was playing football. I was a bouncer at like a 3-story nightclub called Cairo in downtown Orlando. I was involved in some headbutting, and I know a good headbutt when I see one. That was a high quality headbutt. So back to the lawsuit here. Freedom isn't free. This time the mugshot camera malfunctioned too. No body cam footage, or did they malfunction? No, there was no body cam footage, and I don't know whether they had any body cams at that time. Looks like a raccoon with cavity. Oh my God, that's funny. He was in bad shape, and that's what happens to you. I mean, you fight the police, or they think you fought the police, or you hit some of their buddies. So again, this is 1983 case, federal court, Southern District of West Virginia. But yeah, and that's what I was talking about. Fractured nose, multiple fractures of his orbital socket, missing teeth, severe swelling of the face, eyes swollen shut. Underwent a long process of recovery, including dental surgery to repair multiple missing teeth, knocked out by the officers. Period of time, he completely lost vision. One of his eyes, suffered from migraine headaches, severe jaw pain and eye pain. One of the original cops that we know his name, from my understanding, was later terminated from the sheriff's department for making false statements while serving as a police officer, but it was unrelated to my understanding from this case. There was a state trooper who testified, and I didn't handling the criminal case. Usually that is a conflict of interest. There was a criminal defense lawyer who I have a lot of faith in. He's a really good lawyer there in Mercer County, West Virginia, named Joe Harvey. He's been handling this case. This state trooper testified, apparently. So I'm told at the preliminary hearing, and he testified that he observed these John Doe sheriff's deputies beating my client. Subsequently, he's indicted on every charge that they could think of, trying to, absolutely hammer him. Fast forward 2 years later, and that's still going on. He ends up getting out on home incarceration and really does such a great job. The judge lets him off of home incarceration. And he goes about his life, and he was working at this time, and he was a contributing member of society, and he's been so afterwards. But he's obviously had this hanging over his head for the past 2 years. So this is a civil lawsuit. This is for money to get him compensated, but he still has the underlying criminal charges hanging over his head. And of course, that can affect the civil case. So you always want to, if possible, deal with the criminal case before you get to the civil case. Sometimes that's not possible. For instance, here. So here are the claims here. If you're interested in the technicalities of how this works. Count 1, use of excessive force, violates the Fourth Amendment. So Fourth Amendment is not just search and seizure. It's also excessive force. It's technically an unreasonable seizure when the police beat you. So it's a Fourth Amendment violation. It gets more complicated. Once you're in handcuffs in the police car or the processing center, instead of the Fourth Amendment, it then goes to the 14th Amendment. For prisoners who've been convicted, they're in prison. That falls under the 8th Amendment as far as excessive force allegations, and that's just force that rises to the level of cruel and unusual punishment. But that's, again, a different video. This is a basic Fourth Amendment excessive force violation. And if you're interested in how you allege these things, you have to use a lot of specific detail. You can check it out. I'll here in the next day or so, I'll put it up on the website. Again, thecivilrightslawyer.com. But right now, there's important health information up there for you to know. People who want to file civil rights claims, you got to go to a lawyer that knows what they're doing, that handles these types of cases, because it's not like a car wreck case. You don't want to just go to like the regular car wreck lawyer, because they do the opposite. They allege as few facts as possible, because it's state court, you're allowed to do that. And you want to be as vague as possible, because when the client testifies, who knows what he's going to say. Federal court, you got to be very specific. So I even cite case law in here. And then I go through why they shouldn't be given qualified immunity. So count 2 is basically the same thing, but that's for the second incident of where he threw his face into the guardrail. That's count 2, just another Fourth Amendment excessive force case. It's still under the Fourth Amendment. And same thing, you just have to allege very specifically. Now count 3, you may not know this, bystander liability. So what do you do if, say, there's 5 or 6 different police officers involved in a beating situation, or at least those are the allegations, and you don't necessarily know who threw what punch, who kicked what kick, or maybe who didn't do any of it, but just sort of watched? Well, there's a mechanism in the case law for this. It's called the doctrine of bystander liability. So you might have heard that the cops don't have to protect you, that they don't have any duty to protect you from criminals, etc. Well, there are exceptions to that. There's case law that says that, but there are exceptions, one of which is the doctrine of bystander liability. So that means that if there's a police officer who's present while you're getting beaten by other police officers, an obvious civil rights violation, an obvious deprivation of constitutional rights, they then have a duty to stop that, to save, to protect and serve at that point. They have to protect and serve you, and not in the sarcastic sense. If they don't do so, then they can be held liable, just like the other 4 or 5 that actually did the beating, and that is under the doctrine of bystander liability. If it would be readily apparent to an objectively reasonable officer that this harm is occurring, here's the wording actually, but who took no actions to stop it. So, I mean, it's pretty easy to prove. If there's a beating took place, this guy was there. It doesn't matter whether he didn't throw any punches, if he did nothing to stop it. So that, I think, will be an interesting one to follow, because it was in the news when this first happened, but you'd never heard his side of the story, because you had these serious felony criminal charges against him, and he's not testifying yet at that point. So you just hear like the police officer side of the story. But like I said, there was a state trooper who supposedly witnessed and testified to some of the excessive force on the second incident, and also a literal bystander witness who says that he saw him taken out of the truck, etc. That's been sort of my bread and butter is excessive force cases. And that the reason for that is qualified immunity, because it's very rare that police officers get qualified immunity for a police beating situation, because it's very clearly established. There's no ignorance of the law excuse for beating somebody unnecessarily, or for even watching it happen. those are factual disputes which the police officer in question is not going to admit. He's going to deny it generally. And so what do you do when you have a disagreement of what the facts are? You have a trial and you have a jury. Underground auditor. It's a wonder they didn't give me a cavity search when I left that jail. There's no way they could have searched it and found it. I mean, by the time I took that video, it was in my laptop. It was password protected, and they could have done whatever they wanted to me or to my laptop. Well, I guess, it's not like it was on Wi-Fi, so they could have destroyed my laptop and destroyed the video. But it turns out, like I showed you, there's other surveillance footage that did survive that shows him walking into the processing center. And he actually, he except for the blood, he looks worse like days later. And that's kind of common with swelling and the black eyes. Like it'll get worse and worse as time goes on. And originally it might not even look as bad, but 12 hours later, they really are in bad shape. Lulu, is there body cam footage of the alleged attack on the officers? No, there's no body cam footage. We have to take the officer's word for it, one of whom was fired for lying. That leaves my client and also his wife, who was watching from the police car. Good question, Javier. How about the issue with the warrantless entry and them not serving him any documents? So I seriously considered another count in that lawsuit for another Fourth Amendment violation for the warrantless entry into the house for an unreasonable search and seizure. And I went back and forth on it. I thought about it. I researched it. And here's the conclusion I came to, is that primarily this was an excessive force case. And I think that's going to be enough to get it to a trial. We could have made a claim for unreasonable search and seizure, but here's the problem. There was DVPO, Emergency Domestic Violence Protective Order paperwork that was to be served, even though it wasn't served. So in that paperwork, they're going to be able to prove that the wife had consented to their entry into the home, because that's what that paperwork says is you're consenting to going in my home to serve my husband or my boyfriend that lives with me this paperwork. So there's consent. Now, just because they have consent to enter from one of the residents of the house, that doesn't mean that if the other resident is present and objecting, that they can still enter without a warrant. And that's the case of, that's what the law is. So now my client, Dallas, was present. He saw the cops come in his house, and he objected. He refused consent. He asked them to leave his house. So even though the wife gave them permission, technically, as per the documentation, he asked them to leave. So that defeats her consent, because a co-tenant of a home who's present and objecting, that will defeat the consent of the other co-tenant. However, they still would have a great way around that. And that would derail, I think, the litigation, which is unnecessary. I mean, it's about excessive force. It's not about the technical search and seizure violation. And here's how they'd get around that. Exigent circumstances. I don't know if I mentioned it, but there also was a small child that was in the home, a very young child that was in the bedroom next door. Now, I don't believe the DVPO applied to the child. It was just for the wife, best as I can tell, with paperwork that is difficult to get. It was just for the wife, I believe, but it would be enough, in my opinion, and I know how these things go, that they would be able to claim that there was some concern. The child was in the house. They had some concern about the child, about whether or not the child was safe, and that's going to be enough to excuse their presence in his house for exigent circumstances. And I don't agree with that. I think it's possible one could win that argument, but again, unnecessary where we have a beating to this extent on two different occasions. So it's primarily an excessive force case. I do think it also is relevant to the excessive force case, the first one, because it goes into the reasonableness or unreasonableness of their actions, I would argue, because they don't have a warrant. He asked them to leave, and yet they still continued to approach him and eventually hit him in the face with a flashlight. So the fact that they don't have a warrant, they don't have permission to be on the property, that that is usually dispositive of the Fourth Amendment search and seizure issue, except for any possible claim of exigent circumstances, an emergency. They're worried about the child that is somewhere in the house, and especially because the subject is acting erratically, whatever, blah blah blah, they'd come up with. So that's what would happen there. And yeah, we could litigate that, but I think it would be a distraction. Did he resist being detained? In the first instance, the first thing that happened was they hit him. According to our allegations, I'm sure they have a contrary point of view, that he was hit in the head with a flashlight. So at that point, he was seized by them. He did engage in self-defense or self-preservation, which he thought was necessary, and he thought he was going to die at the time. Now, the second time, if that's what you're asking about, it's my understanding that he gave no resistance, that they pulled him out of the car and beat on him, and that he wasn't fighting them. And I think there's eyewitness testimony to that. Red tape, if they're worried about the child or the wife, radio communications should collaborate that claim. Yeah, I don't, as far as I know, there's not going to be any radio communications to collaborate a claim that there was any mention of the child. And I don't think my client recalls any mention of the child whatsoever, that the child was never ever in danger. I just anticipate it. Sure, 4 to 5 cops could have taken him down easily. I mean, absolutely. And the number of police officers, and I don't know what the exact number is. It may be 4 or 5. It may only be 3. I mean, you never know the way things turn out. But that all goes into reasonableness. There are cases that say one big cop and one small woman already is enough to prove excessive force if you have a substantial violence there, because it's a mismatch, as we would call in football. I mean, it's laughable. So that all plays into the reasonableness standard. Does he have any military training or martial arts training that we deem him as a threat? No, I don't think so. He has no training in Rex Kwon-Do. Appreciate you guys watching. I'll do some more about this case. So I'll definitely do more updates on this case as it goes on. I think it's an interesting case factually. And we'll see also what happens with the criminal case as well. So thanks for watching.